and appreciate you introducing your associates.
Good evening, I'm Glenn Funk. I'm the district attorney. On my left is Katie Miller. She's in charge. She's the assistant district attorney and team leader in charge of all of family protection, which includes domestic violence and child sex abuse, child physical abuse. On my right is Michael Brook. Michael Brook is in charge of our HR department, and he's our CFO. He has held that position since he was hired by General Tom Shriver back in 1982 and served through the rest of General Shriver's tenure and then through the entirety of General Torrey Johnson's tenure for those 26 years, and he's serving the same position under my administration.
Well, again, welcome, and we have the question that can you operate within the mayor's proposed budget? And after answering that question, if you have any open remarks, then continue on with your overview of your proposed budget.
Sure. Yes, we can operate under the Metro's proposed budget. As far as opening remarks, when I ran for district attorney, this is my first time in front of this body. I ran for district attorney last spring, was elected in May, took office on September 1st. I ran for district attorney because I had a background and experience of being an assistant public defender, an assistant district attorney, and a private attorney. And I really felt like that experience would enable me to do this job in the best way, better than anybody else in this county. And so I brought that experience to work for the district attorney's office. My main platform planks of my campaign were that I was going to put a real focus on domestic violence. I was going to put a focus on making sure that we prosecuted violent crimes, and especially crimes that dealt with vulnerable victims. I also wanted to make sure that we increased the diversity within the office, because I think it's very important that the office reflects the diversity of our community. And I also wanted to make sure that the office and the administration of justice brought a sense of fairness to the community, and that we used common sense in the way that we allocated the resources that were allocated to the administration of justice. Toward that end, with regards to domestic violence, we immediately beefed up the domestic violence unit within the office, and we now have 8 lawyers assigned to do that work. We are making sure that the lawyers have enough time to actually spend time with the victims of domestic violence to make sure that our attorneys understand their cases and their home situations and can do a proper job to make sure that when the cases are over, that the victims end up in a healthier home situation, and hopefully that the defendants at the end of the time, whether they have to go to jail, whether they can get convicted, or however their case is handled, that those folks end up in a healthier situation. With regards to prosecution of violent crimes, many folks in the community were quite aware of the way that the office handled the Vanderbilt rape trial, and I'm especially proud of the 3 lawyers, Tom Thurman, Roger Moore, and Jan Norman, and the job that they did in making sure not only that those individuals were brought to justice, but they did so in such an open way and such a professional way that the whole community could have the conversation about how sexual violence is wrong, about how we teach our children, and especially our boys, and how we treat women, and how we can treat each other in a way that's respectful to hopefully end up at the end of that horrible and terrible situation of the incident that happened in the Vanderbilt case, but end up with a healthier community at the end of the day. With regard to bringing fairness to the community, we've initiated a number of policies. One example, just in some ways a minor example, but in some ways a very major example. People who have been caught driving on a revoked license. That's not a violent crime. That's not even a victim crime. And yet, in the past, sometimes people whose only crime it was to not have enough money to pay their reinstatement fee ended up incarcerated for months in jail. If someone has their license revoked because of DUI, well, we still hold them to the conviction for driving on a revoked license and follow the mandates of the statutes to make sure that those people are incarcerated. But if it's someone else, then we do 3 things. Number 1, if you can get a driver's license in the short term, we allow the case to be continued in order to have their case get dismissed. Number 2, they're allowed to go to a driver's license reinstatement class and potentially have the case dismissed. But if it's somebody else who is just trapped in a cycle of poverty, then we will amend those charges to a no driver's license and usually not even make that person go to jail, but instead try to enact some sanction on them that is appropriate for the offense. The way that gets translated into the way that the community reaction is, we just recently had CJIS run the number of inmate days just from January 1st till April 28th and compared January 1st to April 28th, 2014 with January 1st to April 28th, 2015. In 2014, there were nearly 6,000 inmate days in jail for inmates who were just serving a sentence for driving on a revoked license. In 2015, that same period of time, the number of inmate days was 1,100, roughly 4,800 less inmate days. I spoke about this with Sheriff Hall, and he said, well, it costs us around $100 a day to house an inmate. So using that rough math, we've saved the sheriff and the county $480,000 just for that 4-month period just by using common sense. And it's not just that money that the county saved, because those individuals, if they're not in jail, are able to be at work, to provide for their families, to pay taxes. And if their charges were no driver's license, that means they don't lose their license for an additional year, and hopefully we can get them back fully participating in society as quickly as possible. So yeah, that's one of several common sense measures that we've instituted, and I really believe that we are doing a great job in the office of making sure that Nashville is as safe a community as possible, that it's as healthy of a community as possible, and that we're going to do our best to make sure that Nashville remains a great place to raise a family and grow a business. With that, I'm able to take any questions.
Thank you. Council Lady Langster.
Thank you, Mr. Chair. Good afternoon to you, I still think of you as the new DA. But what I want to ask you, as it relates to the budget, what efforts have you made to increase diversity in the DA's office? That's where people are really looking for a diverse office, right. Mr. Funk.
We have 61 assistant DAs at this point. When I took office, 2 were non-Caucasian. I've now been in office since September 1st, and I'm proud to announce that there are currently 9 lawyers in the office who are not Caucasian. We have 6 African American, 3 Hispanic, though one of the Hispanic lawyers sits for the bar exam this summer, and when she passes the bar, then she will get one of the next assistant DA positions. She's currently working under the VOCA grant with victim witness. But 9, I also have an offer out for a position that we'll be able to fill on July 1st. I believe that's going to be filled by an African American lawyer, a young man who I know from his past work will do a great job for us. That will get us up to 10 lawyers in the office for the first time in history in Davidson County, and I'm committed to making sure that the diversity of our office reflects the diversity of Nashville. And so I'm hopeful that over the next couple of years we can get those numbers up to at least roughly a third within the next couple of years.
Are you serious? There's never been that many?
Never been 10 minority assistant district attorneys at the same time in the history of the DA's office.
That's incredible. It's hard for me to fathom and to believe that, but you're there every day, and you have money to cover this in your budget?
Well, this was primarily due to turnover. I cannot just go out and hire a bunch of minority applicants. As turnover occurs in the office, then I will go out and recruit. Because I've been in private practice for 25 years, I was aware of a number of people who were excellent lawyers within the community at the time of my election, and I went and I recruited some of these people to join us in the district attorney's office. Some of them took pay cuts in order to come and join the district attorney's office, but they understand that it's important for the whole community to have that type of representation.
Thank you very much. I want to also ask you, did I misunderstand But do you not prosecute, are people not prosecuted anymore for revocation of driver's license?
They are still prosecuted. The police officers, if they catch someone who is driving on a revoked license, will occasionally make an arrest, oftentimes issue a citation. When those folks come to court, if the revocation was based on a DUI and they are on probation, then we still continue to prosecute them under the driving on a revoked license. If they have an opportunity to get their license back, then we give them that opportunity to get their license back, either through continuing the case to let them try to get their fines paid up or go into a driver's license reinstatement class. If they cannot do that, then sometimes we will, or many times we will amend the charge from driving on a revoked license to driving without a driver's license. One of the substantive differences between those two charges is if you get convicted of driving on a revoked license, you lose your license for an additional year. I want the citizens of Davidson County to have driver's licenses for a number of reasons. Number one, there's an ownership in society when you can get your driver's license. Number two, it makes it easier to get back and forth to work and to get a job, and I want people who are able to work to have jobs. Number three, it's an officer safety issue, because if a police officer pulls a citizen over, the first thing they ask is, let me see your identification, let me see your driver's license. When the officer takes that license back to their car, I want them to know what type of person they have pulled over. Is this person going to be a danger? Do they need to get back up to the scene? How careful do they need to be in dealing with this situation? And when we have a valid license, then we have some good identification with which they can make those determinations before they return to the car.
Another question I have is about, I don't know if I heard it correctly or not, but is human trafficking in Nashville, Davidson County becoming a larger issue than what it was, let's say, a year ago?
It has been an issue for years, but it is more of an issue every year. Human trafficking is really an insidious crime. It is depraved individuals who are turning women into sex slaves. As Nashville becomes a destination city for tourism, for conventions, then there are more people who are looking to engage in that type of behavior. But even the folks that aren't just here on a visit, this is an issue for a very small percentage of the population, but it's the type of crime that is one of the reasons why we have a criminal justice system, because anyone who would turn a little girl into a sex slave is really depraved and they need to be in prison. The TBI has recently formed a unit with an additional 4 TBI agents, and they have applied for a grant that would fund additional agents and are forming a Middle Tennessee Human Trafficking Task Force that we have already talked to the TBI and we're going to participate with. Because we hope that with the TBI's help and with the greater sensitivity from and greater awareness of the Metro Police Department to be looking for these types of situations. What I have actually announced yesterday, and we did a press release today, we have formed a unit within our office to make sure that we have a number of points of contact for the TBI or for the police department to make sure that we properly and aggressively, effectively and efficiently prosecute human trafficking cases. That unit's going to be led by Tammy Mead, who's a veteran trial lawyer who's been with the DA's office for roughly 15 years and has tried over 100 jury trials and has prosecuted this type of cases in the past. We also have Antoinette Welch in that unit, who has been doing a lot of work in this area. We've got Vince Wyatt, who has spent 14 years practicing law, some as a JAG officer. We have Zoe Sams, who's already participated in some padlocking of some institutions. And so we're going to do our best through this unit to make sure that we stay focused on this, and as more cases come to us, we want to make sure that we can effectively prosecute these.
So can I say to the constituents of the 21st District that you are looking at this issue very seriously and that you are addressing it with the utmost power that your office can offer?
We are taking it very seriously, and we're making sure that the resources of our office are dedicated to this issue.
Thank you.
Thank you, Council A. Langster. I'd just like to remind you, out of respect for all members in the time frame that we're in, I would appreciate if we could keep our questions budget-related? Council Lady Weiner.
Thank you, Chair. I appreciate it. And thank you for being here this evening. I really have one primary interest, and that's the rate of attrition of our attorneys and the temptation of private practice. And I noted on page E, so I've got kind of a two-part question. On E19-2, under strategic issues, at the beginning of that, it says the hiring and retention of professional, qualified, experienced prosecutors. How do we know that we're getting the best return on our investment, first of all?
The people in our office, I can report, are extremely hardworking, extremely diligent, extremely smart, and care passionately about serving the community. It is always tough to deal with financial issues when the lure of private practice is sometimes very lucrative. I myself left when I was 29 years old after serving as an assistant DA for 3.5 years, and did very well for a long period of time. What I'm trying to do is trying to make sure that every lawyer in the office feels that sense of accomplishment at the end of the day in knowing that they have served the community well and that their service to this community has actually made a difference in making this a safer place and a better place to live. With regards to, I really believe that the lawyers in our office make the best law firm in all of Nashville. And they make a fraction of what the folks at Bass, Berry & Sims make, or the folks at Waller Lansden make, or some of the folks that are just doing it in small firms or on their own. And we will always have a certain amount of attrition just from folks who, because of where they are in their life, they need to be out and working on their own. But I can report to you that we have the best law firm in Nashville. There are challenges to maintaining that, but by keeping them trained up, keeping them challenged in their work, and keeping them engaged, I'm doing my best to make sure that we keep the best people possible.
What's the average experience level in terms of percentages of the prosecutors in the office?
It would be hard to say what the average number of years of experience. We were going over some documentation today. With the turnover in administration for the first time in 26 years, there were a number of prosecutors that left, but I was very fortunate in being able to recruit some great prosecutors to either come back to the office or join the office. So we had 4, 5, 6 hires that were fresh out of law school, but we also have brought in folks with 25, 30 years of experience into the office. We brought back a number of folks who had been in the office for a number of years, left and had been practicing in private practice, and I was able to convince them to come back to the office and bring that experience. To me, I value people who practiced on both sides. I think my experience as a public defender made me a better assistant DA. My experience as an assistant DA made me a better defense attorney. My experience as a defense attorney is making me a better elected DA. For instance, we just hired a man named Robert Jones, who has over 30 years of practice. In fact, he was the public defender in charge of the entire public defender's office in Memphis. But he is now in our office and brings that experience to work in leading a unit and prosecuting. Derry Harper, who we were able to recruit from the city attorney's office in Memphis, who'd been an assistant DA back in the 1980s under General Shriver and a U.S. attorney under Joe Brown. He has over 30 years of experience, and I was able to convince him to come and join. So we lost some folks with some experience, but we've also gained a number of lawyers with great experience. I'd say on average, and I can get this information to you if you'd like for me to actually calculate but best estimate off the top of my head was I bet our average number of years of service total for if we averaged the 61 DAs would be around 10 years of experience.
Thank you.
Long lawyer-like explanation for a relatively short question.
Councilman Glover.
Thank you, Mr. Chair. I have a couple of questions, and I believe they are truly budget related. As you know, last week there's some question with regards to PTO time, and then perhaps the taxpayers picked up a bill for time that may or may not have been worked. So the question is this, not to defend that, but the question is this, would you begin or look and consider adjusting your employee manual to mirror that of Metro, since Metro seems to be picking up the majority of the tab for the employees. You can answer that later or now if you want to. But then the second question that I have is I started digging around, finding out who pays what on the tab. With the public defender under state direct revenue, they show roughly $2.2 million. Under state direct revenue for the district attorney's office, it shows $40,000 and it's budgeted $40,000. Is that all we get from state direct revenue? Is $40,000?
That's witness transportation reimbursements.
That's what transportation.
Just for witness transportation.
That 40,000 is just for witness transportation.
Okay. Is there any other state revenue that comes
Sure,
in? Where am I missing it?
I don't see the state budget.
The state full budget, personnel and benefits, $6,225,000, state contractual, $560,000.
Okay. So are we reporting it two different ways as far as the public, John, we are reporting it two different, okay. So it's not apples and apples that I'm.
That's in the state budget, it's not in.
Okay, I was just trying to because I'm like, there seems to be a large discrepancy. Okay, and I mean, if we're saving $480,000 for the program you've implemented, I think that's exceptional. You know, when I was on the school board, I always believed that we need to have the students in the classroom versus on the streets because they can't learn. At least they don't learn the right things being out of the classroom, so I congratulate you on that. Thank you, Mr. Chair.
Thank you. Councilman Tigard.
Thank you and welcome for your first time. First question concerns your new office space, 46,400. Is it more square footage? Is it plusher? What's the increase in office rent?
Around 10 to 15 years ago, the district attorney's office moved out of this building, the old historic courthouse, and rented space in the Washington Square building.
Correct.
Pursuant to the lease, there was an increase as of this year for the dollars per square foot. And so we haven't made it more plush, and we haven't contracted out any additional space.
So additional, same
lease.
space, just additional rent per lease agreement. And are there more increments coming in future years, or when does that bump?
I'll send that to you, Councilor.
Okay, all right. All right. You heard my questions to other elected officials about the scrutiny on elected officials and the time spent in the office and whatnot. Would you support an effort to have a voluntary disclosure report for all elected officials filed with the clerk's office on time worked during the year?
Yes.
Okay. Obviously, there were some rough patches when you first started and some misconceptions and media reports and whatnot, but I would feel compelled to ask you in the controller's report concerning the state pension and health insurance and then the eventual turning that back in, but there was a statement in there about the abuse of public money in the controller's report, and I didn't bring the whole thing with me, but that was the one statement that caused me great concern. Would you want to address that before us at this stage?
All at this point was a referral to the comptroller's office by a district attorney's conference who wants to be completely transparent. They said, if I'm thinking of the same docket that you're referring to, they said it could appear to some that this could be whatever the language was.
Abuse of public money.
The comptroller is looking into this, and the comptroller will issue a report at some point. I'm not sure when, but I would expect it to be somewhere around the end of the fiscal year.
Okay, so sometime June 30th or before we would.
Well, maybe a little bit after June 30th,
after.
once the fiscal year closes.
Okay. The issue about vacation and time off pay and whatnot, a new employee who happened to be your campaign manager, there was some scrutiny about signing for vacation days after the date and whatnot. What's the issue there? Or what's the policy on vacation days for employees?
Well, there's a policy for employees, there's a policy for attorneys.
Okay?
For attorneys are supposed to fill out a form that we have that document their personal time off. What I have heard is that historically that has been a battle to make sure that attorneys do that all attorneys do that correctly. Mr. Teets did not do that. He didn't do it correctly, and his supervisors did not get him to do it on time and appropriately. Once he resigned, Mr. Brook attempted to piece together what he could, primarily because what he was trying to do is make sure that we did not owe him any banked vacation time. When questions arose, I said to Mr. Brook, let's go back and you go talk to his supervisors, review the assignments, and see how many days he actually took off. And they compiled that. I believe he actually took 8 days off in 2014, and he took, to the best of our documentation, somewhere between 10 and 14 days off during the first 5 to 6 weeks of 2015. He would have had a bank of 24 days to take during 2015. He was using those up at a too quick of a rate, but in February he left our office and signed on with one of the mayoral campaigns.
All right, so policy allows someone to take all their vacation in the first half of the year and in theory hasn't earned that entire year's vacation?
They get credited with those days to take off on January 1st, and at that point they can take it at their discretion. They need to coordinate their schedule with their team leader to make sure that the dockets are covered and that no cases are left unattended.
Do you have to sign off on that, or does the team leader sign off on that?
Ultimately, the personal time off sheet, which they are supposed to turn in as soon as they're done with their personal time off, or preferably even before they've done that, they've taken their time off, ultimately that comes to me for my signature.
Okay. I may have another question, but I won't take any more time.
And we have, because of this issue, we have stressed to the team leaders, let's reinforce to every attorney, this is what we have to do, and we can't make that.
Is that form too difficult or tedious, or
no?
It's just not in the habit of doing it?
It is not a tough form, and there's no excuse for that not being done.
Okay.
Councilman Claiborne.
Thank you, Mr. Chair, and thank you, Mr. District Attorney, for being here. And I want to compliment you, first of all, for your emphasis on prosecuting domestic violence and serious criminal offenses. We need to be as pointed and focused as possible in those areas. So I compliment you on that. A couple of questions following up on previous questioners. I had in your strategic issue that Council Lady Weiner related to the hiring and retention of professional, qualified, and experienced prosecutors, and you went through a number of different individuals by name and the years and the experience that they bring. I was looking over the resume of Mr. Teets. Could you explain to us how he qualifies as a professional, qualified, experienced prosecutor?
Well, what I look for is people with good judgment, first and foremost. I look for people who are smart. I look for people who I believe will do a good job. I had just gotten through a very intense 4-month period where I knew that he was incredibly smart, where he worked really hard, and where he had demonstrated good judgment. When I was recruiting people to join the office, who I thought shared my vision for operating an office that would stress protecting victims and stress being fair. I thought he fit the bill perfectly. Did he have a lot of prosecutorial experience? Well, he had interned with the district attorney's office where he went in the town where he went to law school.
2009.
In 2009, and so he had some prosecutorial experience, but more than that, what he had was a life experience and a professional experience that I thought would be an asset to the office. When he joined the office, he was assigned, as many people who are fairly new prosecutors, to the general sessions team. Of the new prosecutors that we hired, people who had not been in criminal practice to a great extent. That would include, there were 3 women who had just graduated from law school. They were put on general sessions teams. 2 of them are now on the domestic violence team. I'm trying to think who the other, there's one other young man and he's on the general sessions team as well. The general sessions courts handle misdemeanors, and they also handle the initial court appearances for felonies. That they can handle a felony through a preliminary hearing, and then it gets bound over to the grand jury, where one of the felony teams and seriously experienced lawyers take those cases up and handle those through a jury trial. So he was placed in with the folks that had less experience handling criminal cases.
Okay. Following up on Charlie's line of questioning there about funds and the proper use of funds, did I hear you say that your policy manual, you have a District Attorney General's personnel manual that was apparently reprinted in May of 2014. So tell me who is subject to that policy manual and who's not in your office?
Well, the policy manual makes distinctions between employees and attorneys.
Okay, so how many?
And so everybody is subject to the policy manual.
Okay, I guess what I'm getting at here is that in the manual it says that an individual who is hired between July and December receive 3 days for use in the remaining year. Who does that apply to?
Those are brand new employees, and when an attorney comes in with years of experience of credits for having been a licensed attorney for a number of years, they come in at that level.
So because Mr. Teat had been received his degree in 2009 but actually hadn't worked as a prosecutor, he received apparently 8 days. What experience was that based on?
4 years of experience would mean 24 days. He came on September 1st, so the last 1/3 of the year, he would get 1/3 of 24 days.
So which 4 years of experience did he have? When I look at his resume going back all the way through 2009, I believe it is, 2010, he's worked as a political operative. He's been as chief of staff in a political a state senator's office, and he's run campaigns. So when did he have time to work as a prosecutor?
He's been a licensed attorney for 4 years, and that's what we base it on.
So
based on where they grade as far as how many years they've been licensed.
So it doesn't have anything to do with whether he's actually had experience in the courtroom. It's just how long he's had his degree?
That's correct.
Okay, so your employees then, who are subject to this policy manual, they have to work 3 years to get 24 days of PTO. So he worked, how long did he work?
He started on September 1st of 2014.
And finished when?
Second week in February, first or second week in February.
First or second weekend. So he took a total then of 8 and 10, according to these PTO sheets, 20 and 10 and 18, so that's 38 days.
Those PTO sheets were created to make sure that we did not owe him any bank time, and those were created by the HR department, Mr. Brook. Once questions came up, we went back and talked to his supervisors, cross-referenced with their schedules for when he was on the schedule, when he was off on the schedule, and the true number was 8 days in 2014 and roughly 10 to 14 days in 2015.
Okay, so with the exception of one of these, there's on October the 24th, he wanted 10 days for other. And there's a note here that this was requested by email or phone, that it was not available to sign this sheet. And then you eventually signed off on this on February the 29th of 2015. So we've got several months of that have transpired there. So how do we know whether he took those days or not?
Well, what happened was, once he left in February, the HR department attempted to determine exactly what days for sure what days we knew that he was not working, so that we could then make sure that we did not owe him any bank time. How do we know what days he worked? Well, once I said to Mr. Brook, questions have come up about this, let's go back and cross-reference with his supervisors and see what we can actually document. We've been able to document that he worked all but 8 days in 2014, and we've been able to document all but roughly 14 days, but we've also got notes from his supervisor that he was assigned as a floater between General Sessions courts on some other days, which we think puts that number between 10 and 14. General Sessions dockets, we will have running up to 8 General Sessions dockets a day. We have to have DAs in every one of those dockets. Some of those dockets get backlogged because sometimes, for whatever reason, because of a high arrest rate or continuances, there may be more cases on a given docket than on another docket, and sometimes some long-winded attorney might have a 2-hour preliminary hearing and things get behind on a given docket. And so when we have a floater available, then we can have that lawyer, while one district attorney is conducting the hearing, then the other district attorney who's floated and been assigned, as needed during that morning, can go ahead and be working on the other cases, servicing the victims, negotiating cases with the defense attorneys, and getting other cases prepared to where the other folks who have been patiently waiting in court, the other citizens who are subpoenaed into court, won't just have 2 hours of their lives gone, evaporated. We'll be making progress to where we can be efficient when that hearing or trial is finally concluded. So that's what he was doing during those days, according to his team leader.
There's an email that was sent on Sunday, January the 4th. It says, Seems Teets has moved on to another political election and will not be part of our team any longer.
Mr. Claiborne, Councilman Claiborne, I would appreciate it if you would.
This goes directly to the.
If you would continue to ask questions pertaining to the budget. Thank you. Please, sir.
This has to do directly with the salary of this individual. We are being asked to, this comes from the tax dollars of the city, and so this is part of the budget. So my question is, this individual was apparently identified as having left the office on January the 4th. And in this email directs individuals to cover his slots. January the 12th through the 16th, Jeff is covering Teets slots. January the 20th through the 23rd, and also the 28th through the 30th, Brian is covering Teets slots. It says, was he removed from the payroll when this information came into your office? And if not, why not?
We heard that he was leaving to join a campaign that was coming up on Monday. He was not hired on that campaign on Monday, and so he was not removed from the payroll.
So did he cover these slots then?
The first week in January, he did not cover those slots, and those were part of the PTO days that he took. That's part of the 10 to 14 days that he took.
Okay. When I met with you after your initial rough spot that Charlie referenced, And after you came forward and said, you know, I'm gonna wipe this clean here, we're gonna put this behind us, and we're gonna go forward, we're gonna do the right thing, then I'm thinking, yay, this guy's moving in the right direction. But it seems to me that the impression of wrongdoing took place. The impression of a misuse of public funds took place. And in the public's eye, impression is often a reality. And so this reflects poorly on the management of your office. When you backdate, you know, as an attorney, you should understand the importance of backdating documents. If I were an attorney going in to prosecute a case and I had backdated documents as a part of my evidence file, I would be all smiles. And so when you have information that doesn't line up, and certainly doesn't line up with the manual, the general public doesn't understand that there's a difference between attorneys and regular employees. And so I'm just saying that when you ask us to fund your office, we sign off on those dollars, and we expect those dollars to be used in a manner that buys us the most bang for the buck. And it apparently seems that in the case of Mr. Teets, that wasn't so.
Councilman, this policy has been in place at least since 1994. And what happened with Mr. Teets's employment is not something that has never happened before with regards to attorneys not properly filling out PTO time. I can promise you that we have redoubled our efforts to make sure that these PTO forms are filled out completely, accurately, and promptly. Did we fail on making sure that his time in 2014 and 15 were properly documented? Yes, he did not follow the policies and procedures that had been explained to him and that we've gone over as an office. Michael Brook has been our CFO and our HR person since 1982. He's the one who prepared this and did his best to come up with documents that demonstrated that we did not owe him any additional funds, and then he went back through and made sure that this was not something where, pursuant to our policy, which I could, pursuant to the policy that's been in place for some 22 years, 21 years, grant discretionary time above and beyond those dates. But in fact, we didn't need to do that because it fell within the proper parameters. With regard to Mr. Teets, I think he did an excellent job during the time that he was in our office, and I think he contributed to the office. He has now left the office. With regards to every other attorney in the office, we are doing our best to train them up and make sure we keep this on a short leash with regards to properly filling out the paperwork. As I told Councilman Taggart, this is not rocket science to fill out this paperwork.
I wouldn't think so.
I think hiring Mr. Teets and having him employed was being a good steward. He was a good lawyer, and he did do a good job. With regard to this PTO time, he did make a mistake, and it's not going to happen again.
Thank you.
Council Lady Blaylock.
Thank you. I'll be quick. How many cases did Mr. Teet actually have?
Well, on a given general sessions docket, you might have as many as 40 or 50 on a given day. These are general sessions cases. It can be anything from something as simple as a driver's license case or a paraphernalia case or criminal trespass case, all the way up to something more serious like a serious felony. But in general sessions, you can't have a jury trial or plead anybody guilty to a felony. So it would have been probably dozens every day that he was assigned to handle a docket. I don't know that we could even find a way to calculate all the cases that he did during his tenure, but it was a full load. It was what everybody else that's doing a general sessions docket handles did.
Okay, that was the question. And also, I'm looking at our sheets that we have here. Can you tell me what your salary is?
What my salary is?
Mm-hmm.
144 plus the 20,
Okay.
so 160.
$144,000 from the state, $20,000 from Metro.
Okay. All right. Thank you.
Okay.
Councilman Glover?
This is not a question, just a quick comment. I think what I've heard here today certainly screams of why you need to review the policy, simply because, and as I'm listening to you define Mr. Teets and talk about how smart he was brilliant, because he worked until January the 2nd and got 24 days that we may have owed him. And so I think that in itself demands a hard look at the policy and maybe redividing it to where they are receiving a time off per quarter. And if they want to hold it until December and utilize it all, it may be something to consider. So just a comment, not asking you to comment back or to make a statement. And thank you for your indulgence, Mr. Chair.
Thank you.
Thank you. Council Lady Langster.
Thank you, Mr. Chair. Attorney General Funk, do you plan to be a good steward? You are a good steward of the taxpayers' dollars. Are you going to examine the records as carefully as you can as the head of the district attorney's office?
Yes, ma'am.
Thank you, Council Lady Langster. General, I have one question, and that's pertaining to the budget of, we're having the Family Justice Center. The police department has a victim intervention center or section, and the district attorney's office has a victim witness program. With this new Family Justice Center coming online, I'm seeing that there might possibly be some overlap of victim witness people. So I was just trying to get, I mentioned to you earlier about this. Will there be with this joint one-stop shop, I guess, for lack of better words or phrase, for the Family Justice Center, exactly how many victim witness people and where are they all coming from? And if you don't have the figures now, you can provide them to me at a later date. I
actually do, and I want to explain so that the council understands the difference. We have in our office victim witness advocates. Their job is primarily to assist victims, help them prepare for court. In the family justice system, there are victim advocates, which sounds like a synonym. And obviously we want to make sure that there's not a duplication of services. The victim advocates that the Family Justice Center has, their job is to assist victims in securing orders of protection, which is a civil function, and so we cannot assist them in obtaining orders of protection. That's a civil function, and criminal lawyers cannot participate in that process. They also, those victim advocates that work for the Family Justice Center, provide court advocacy, have people there assisting people who are seeking orders of protection in general sessions, in Third Circuit and in First Circuit. They also assist victims who arrive at the Gene Crow Advocacy Center on a walk-in basis that do not have cases in the criminal justice system. Also, if a victim arrives at court because they've been subpoenaed but they are unsupportive of prosecution, many times they are more open to having victim advocates from the JCAC help them get plugged into some of the nonprofits that are there to work with these folks who've been victims of domestic violence and get them into healthier relationships that they might not hear from us. These folks do not provide any information or advice regarding criminal prosecution. That's what our victim witness services do. The JCAC advocates have to remain neutral, but we can, because they can't be pushing anybody to prosecute. But that's what our victim witness folks are doing, is making sure they understand the criminal justice system and helping them understand, what the system is about, what questions they're going to be asked, what different remedies we might have for their situation. Before court, the victim witness folks from our office tries to contact women women or men, but it's primarily women, who are the victims of domestic violence within 48 hours, and we're trying to get it done within 24 hours of the arrest to make sure we've talked to them and started to establish a connection. The people at the Family Justice Center do not have contact with these victims prior to them either coming into the JCAC or prior to the court date. On the day of court, the victim witness from our office checks in police officers, ensures victims can get to the JCAC. They keep victims and witnesses apprised of case status, prepares witnesses to testify, and they explain any plea negotiations. Whereas the JCAC, the victim advocates, instead of preparing for court, they try to provide victims with a personalized safety plan. They assess a victim's level of risk for being murdered using an evidence-based danger assessment. They conduct a full needs assessment for the victim and for her family and provide necessary referral services. They escort victims to and from court for their safety, and they sit with victims in court. After court, the victim witness folks from our office have a very specific job. They document dispositions, they do the filing, they maintain case statistics, and they inform victims of new court dates. Whereas the JCAC, the Family Justice Center's victim advocates, they do service provision and follow-up, referring the high-risk cases to the Police Domestic Violence Division and calling victims to see if they need further assistance. So while the titles sound so similar that you might think, well, these are actually an overlap position, their job descriptions are very different because of their roles in the criminal justice system. So with regards to the folks that at the Family Justice Center and the folks in our office, they're both serving very, very important needs as we try to change the culture in this community to make it a safer place.
Thank you. Now, I know at one point, some of the victim witness coordinators or advocates in your office or in the district attorney's office at the time voluntarily did some of those because of their need. Is that correct? But now with these additional people from the Family Service Center, they will not have to. They won't be performing some of the things that they once did. Is that right?
Well, we had never been able to provide a personalized safety plan. We had never been able to do a danger assessment or a lethality assessment. While we had already done, and we continue to do, attempt to get folks plugged into proper nonprofits that are providing support for folks that are in danger. We were unable to do the needs assessment that's being done. Escorting victims to and from court, we still do some of that, but that is, a very small percentage of either job. But that's a small overlap there. And with regards to calling victims to see if they need further assistance, our office has historically not done a continued follow-up once the case is over to make sure that people are following up with their safety plans, because we've got a whole nother day's worth of a docket the very next day. And luckily, and in a huge improvement thanks to the mayor's initiative and thanks to Diane Lance in particular, and Whitney McFalls as well, we're able to actually follow folks once they have left the court system to try to help make sure that they don't come back into the court system. We want for victims to get into healthier relationships where they are no longer the victims of domestic violence.
Thank you. I just needed some clarification because it did seem a little confusing there with all the different agencies with their victim advocates. Well, that concludes your portion of the budget hearing, and we certainly appreciate you being here and answering the questions.
Thank you.
Thank you.